Buckle up, because this isn't your average court hearing. This guy's behavior is straight out of a reality show meets a jailhouse meltdown. He's on parole, caught new charges, and somehow thinks firing his lawyer mid-hearing will solve it all.
This is Mr. Niegos. Are you able to see and hear me?
Yes, Judge.
This is case number 253691 FY, the people of the state of Michigan versus Bobby Lee Du Bois. We were scheduled today for a preliminary examination. However, the court received some information regarding some security issues. One is it was related to the corrections officer that Mr. Du Bois threatened to punch the corrections officer. There was also a message that was intercepted by the corrections office through the communication system that was sent yesterday at approximately noon or 11:47 a.m. in which, from Mr. Du Bois' account, it says, listen, I don't care no more. Says don't watch what happens. I don't even come to court tomorrow because I'm going to flip out on this mother effer, and that is not what's said, but I'll clean it up. I'm going to show them a side they've never seen. If I could get within an inch of a guard or with that prosecutor, I'm going to effing choke the life out of her. Due to the security concerns, the court requested that corrections take certain precautions in which to bring Mr. Du Bois to the courthouse for his preliminary examination. However, the corrections officers could not do that because it's reported that Mr. Du Bois may have broken an ankle or a foot due to mule kicking a door. So the court finds for good cause, due to security purposes, we are not having the preliminary examination today. That will be adjourned to a later date. Also, it's now determined because a threat has been made against the prosecutor whether or not a special prosecutor will need to be appointed in this case moving forward. So that is going to potentially delay this case. We will reschedule it for again next week to see where we're at.
So we've scheduled this 5 times already. That's why I'm in the situation
Mr.
I'm
Du
in.
Bois,
I've been patient with you, Your Honor. I have. We are 55 days into this.
For the record, I have muted Mr. Du Bois because he is interrupting the court proceedings. Counsel and I had that meeting in chambers before, and it was decided that this is how we were going to handle it. As I said, Ms. Carey is going to determine whether or not she needs a special prosecutor. Mr. Niegos, it's questionable as to whether or not he's the MFer that's referenced in the message as well. And it's my understanding he's going to make a determination as to whether or not he'll need to withdraw from the case also. Counsel, have I summarized what we've discussed and what's happened so far in this case? For the record, Mr. Du Bois has walked out of the communications room.
Yes, sir.
You have, Your Honor, in the interest of efficiency and to alleviate some of the concerns that Mr. Du Bois started putting on the record, whether fair or otherwise, the plan was to have him briefly placed under oath and just inquire as to that simple fact. But I'm not sure that would be productive to do so today. I leave it to the court's discretion, but in terms of the court's question as to was that an accurate summary of what we discussed in chambers? It was.
All right. And for the record, Mr. Du Bois is back in the Polycom room. So for those reasons, the court does find good cause to adjourn today, and we will be back on a different date and see procedurally where we're at. We are adjourned. Thank you.
Thank you, Judge.
So yeah, this genius actually sends a message ahead of time warning the court he's going to flip out. That's like emailing the police before robbing a bank.
All right, court calls the people of the state of Michigan versus Bobby Lee Du Bois, case number 253691 FY. Appearances counsel, starting with the prosecutor.
Joanna Carey for the people.
Good afternoon, Your Honor. Ryan Niegos appearing on behalf of Brandon Du Bois.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case. Mr. Niegos, I know you had mentioned some issues before we actually got the case called. Is there anything you'd like to address on the record?
Yes, Your Honor. I would just ask my client to confirm. We had the discussion yesterday. He indicated some concerns about a potential change or a request that the court recuse itself. such that a different district court judge would hear this matter given the court's prior employment status. In my discussion with Mr. Du Bois yesterday, my conclusion was that it was insufficient to even make the request, but I would just ask for the court to ask of my client at this point in time, or allow me to ask him, basically, Bobby, do you want me to ask the court to recuse itself at this point in time, based on what you and I spoke about last night?
I do, and there's a couple other things that I would ask the court to hear me on before that as well. I'm not sure if the court is aware that there is an open investigation on the said officers that.
Okay. No. We're not gonna do that. I'm on Zoom. We're not doing this. So if you believe that because Judge Wiggins was the prior Wexford County prosecutor and had worked in the prosecutor's office, are you asking me that I ask that he recuse himself, knowing that there's going to be a new judge that's going to be presiding, likely Judge Ransom, which is going to mean additional delays just to have this hearing done? You understand that?
I do.
Judge, based on my client's discussion yesterday, based on his representations today, understanding how clairvoyant and I guess that's not the right word, just how candid and transparent this court is in terms of its beliefs, I'm not sure ultimately, Mr. Du Bois is of the opinion that, he was previously prosecutor, or attempts at prosecution were such when you were either the elected prosecutor or you were an assistant prosecutor. Based on his representations and his concerns on record today, and the fact that he's telling the court he understands this is going to be additional delay in proceeding to a preliminary exam, I would ask that the court graciously recuse itself, and I assume Judge Ransom would be the step-in judge.
The irony is delicious. He keeps yelling about how slow the system is while being the reason it's crawling at turtle speed. Self-sabotage level. Expert.
Well, I don't think there's anything specific in that request other than that you were the prior prosecutor, and I don't think that alone is enough for you to recuse yourself, and it sounds a little bit like judge shopping on the defendant's part, frankly. So I would ask the court to deny the motion.
Thank you. The defendant's request for me to recuse myself is denied. I do not believe I have a conflict in this case, nor a reason to recuse myself. If the sole reason to recuse myself was because I have a defendant in front of me in which I was the prosecutor prior, I will say, other than maybe one judge, there's not a judge in this 2-county area that would be able to hear the case. Additionally, I don't believe just because I was a prosecutor, both elected and a chief assistant, doesn't rise to the level of being recused. I will state before that I was a public defender. I will also state that while I am familiar with Mr. Du Bois' name, I can honestly say I do not remember one case that I prosecuted him on. So I don't believe we've risen to the level of a need to recuse myself.
Yes, Your Honor. Thank you.
Mr. Niegos, are you requesting to move forward then today with the preliminary examination?
Yes, Your Honor, please.
Any additional matters before we start?
I would just ask that the witnesses be sequestered.
Ms. Carey, do you have any witnesses? All right.
I don't.
I will order that any witnesses be sequestered. I will also state for the record, because we didn't do this before, Mr. Niegos appears by Zoom and Mr. Du Bois appears by Zoom from he appears by the Wexford County Jail. Due to some threats that were made last week, the court felt it best for court security purposes to conduct this hearing by Zoom. Ms. Carey, your first witness.
The people called Deputy Shane Rojas.
Your Honor, can me and my attorney have a moment in the breakout room, please?
Mr. Niegos, you want a moment?
Yes, Your Honor.
And here comes the conspiracy subplot. Every courtroom meltdown needs one. The defendant claims there's a secret investigation. Spoiler, there isn't.
Mr. Niegos, have you had the opportunity to discuss matters with your client?
I have, Your Honor. I didn't get a full and complete opportunity to explain to my client what I'm about to say on the record because I didn't get a chance to speak. But essentially, my client's request is as follows. He wishes me to ask for an adjournment of this matter because he has initiated a, as he calls, an investigation into the actions of the primary troopers who investigated him in this event. He believes that the results of that investigation are paramount to his ability to present a defense in this case. He's also instructed me to subpoena some guards from the local Wexford County Jail for, at this point in time, I'm not sure what reason that would be towards a preliminary examination, but that's nonetheless his request. And the thing I didn't get a chance to tell him is to remind him that as this entire proceeding is now pending, he has no bond, he will have no bond, he's sitting on dead time, there's a parole hold on him, and whatever this MSP investigation that is or is not happening, he believes that it is. I have no information or knowledge of, nor do I believe it's paramount to my ability to effectively represent him in this case. That being said, my understanding is he wishes me that I ask for this adjournment, which I'm doing at his request against my advice. And I would ask that the court ask him directly if that is in fact the case, if he does in fact that this examination be adjourned once more, even though I'm here prepared to go forward today, despite his earlier complaints about how long it's taken to get all this here. Thank you, Judge.
Mr. Du Bois, your attorney has placed on the record your request. Is that your request?
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter, and I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it can be pertinent to what we have going on, and I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's going to be wrongdoing found, I believe.
So, Mr. Du Bois,
in regards to this,
what is the nature? And I don't want you to get into the facts of it, but what is the nature of your complaints of Michigan State Police?
It's not the Michigan State Police, it's Deputy Roloff and Deputy King of the Grand Traverse County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King.
Are you alleging
in regards to the drug, in regards to the possession? I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
The prosecutor's not having it. Translation: Judge, this guy's full of it. Let's move on before he starts quoting YouTube law school again.
Absolutely not.
All right, Ms. Carey, any argument?
Can we have Ms. Chandler subpoenaed to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know something that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week, and I don't want to have them come back for the 5th time next week. So if we're going to have that investigated, let's not schedule it until we're certain that investigation is over, then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation, and I will admit it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But the court and staff are willing to, if the party, Mr. Boys, it's my turn now.
Yes, sir.
If the parties are willing to hang over, we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough, and now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you didn't have a prelim last week because of your own actions, and now you're asking for another adjournment today.
That I did.
I'm not,
that it was my fault. My trial rights are being violated, and you're just letting it happen. That's why Ransom was going to throw it out the first time. What do you, I'm not being hurt. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. How am I getting an unbiased, fair chance here? Furthermore, I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me.
Of course he is. When in doubt, claim everyone's lying. The judge, the prosecutor, the cops, probably even the guy running the Zoom meeting.
At this point, I would like to dismiss Mr. Niegos under the, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions again, for the officers. None of this stuff. I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are, and every time I don't, I get pushed through this system and I get screwed around. I do. And the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos?
I'm sorry, it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Your Honor, I obviously I'm yammering and stammering. I'm not entirely sure what to say. He's representing. He knows his rights. He's representing. He tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the notes from last week. He indicated he was not referring to me or my firm. As such, I was going to continue with him. Based on his representations here today, I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, I take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
What about the interview between us that was scheduled yesterday? You've missed two Two.
Okay,
Two
Mr.
times
Du
you're
Bois,
supposed to have
this is
your
Mr. Du Bois.
perfect
This is the
man.
perfect example. He's saying that the communication process is broken down. He wants out, and yet you want to argue with him. Why, I don't know, but you want to argue with him about
Because I
that.
want it on record why. I'm not just being disruptive. I'm stating what's going on. I should have an attorney that can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, the lawyer sees them for 5 minutes, they don't go. How much time have you spent on my case?
He's doubling down like a conspiracy theorist on caffeine. At this point, even his own lawyer looks like he's spiritually left the building.